Good afternoon, honorable members. Once again, welcome to this meeting as we continue dealing with public hearings from those organizations and or individuals
Recording
that
in
made
progress.
substantive written submissions on the Prevention and Combating of Hate Crimes, Hate Speech Bill. Let me also welcome the parliamentary legal team, as well as the legal team from the Department of Justice who are on the platform. And I take it that also some of the stakeholders are on the platform. Welcome to yourselves as well. Members, just in terms of today's proceedings, we expect presentations from the United Ulama Council of South Africa, Cosatu, the Gender Diversity Coalition, the Cause for Justice, Media Monitoring Africa, the Association of Christian Media, and Lita Labantu. I should just indicate to members that the Cause for Justice presentation will not be made. We received an apology from Mr. Ryan Smith, but be that as it may, we'll adjust the program as we move along. That being said, honorable members, the first presenter is, I don't have a name, Mr. Mohammed, I think. Yeah, Mr. Mohammed. I don't know if he is present. Gershwin, please assist me.
Good afternoon.
Oh, good afternoon. Let me take this moment to welcome you to the meeting of the Select Committee. We've received your presentation on the Hate Crimes, Hate Speech Bill, your written submission. And we thank you for wanting to make an oral submission to the committee as well. We would give you 15 minutes to do that. Thereafter, as the committee members will then ask you questions for clarity. And we request that if you could please focus on what your issues are with the bill and what your recommendations are. Over to yourself, Mr. Mohammed.
Thank you, Mr. Chair. Good afternoon, honorable members and all other participants. And since we are discussing hate crimes, allow me to greet you with a universal greeting of peace. Assalamu alaikum wa rahmatullahi wa barakatuh. This law will create two crimes, the offense of hate crime and the offense of hate speech. The bill describes a hate crime as defined as an offense recognized under any law committed by a person who is motivated by their prejudice or intolerance towards victims. The words prejudice and intolerance are not defined by the Act. We don't know whether from this time when this Act is enacted, whether from that moment onwards, nobody will be allowed to hold any prejudices or intolerances. We don't know whether people will be allowed to hold prejudices or intolerances, but only to a certain extent. And we don't know where that line will be drawn. The bill doesn't help us. The offense of hate speech is committed when a person communicates in a manner that shows a clear intention to be harmful, to incite harm, or to promote or propagate hatred. The words harmful, harm, and hatred are not clearly defined. The word harm is defined in Section 1. However, the definition doesn't tell us much. It doesn't tell us the precise conduct on the part of the accused which will constitute harm. It does not tell us what effect on the victim will constitute harm. Allow me to demonstrate by way of an example. Murder is defined as the unlawful and intentional killing of another person. In this example, we can see that the accused person's conduct is clearly described, as well as the effect on the victim. attempted murder is more or less the same, except that the effect on the victim is different. Here, the victim survives. Again, the conduct of the accused and the effect on the victim is clearly described. The bill defines harm as substantial emotional, psychological, physical, social, or economic detriment that objectively and severely undermines the human dignity of the victim. Here again, we have a phrase that does not put meat on the words of the constitutional imperatives. Practical implementation of the law requires precision in the meanings of these pivotal words. Otherwise, it results in vagueness. Regarding this vagueness, the Constitutional Court said that a norm, a rule, cannot be regarded as a law unless it is formulated with sufficient precision to enable the citizen to regulate his conduct. He must be able to foresee the consequences which a given action may entail. The same court said in another case that it is an important principle of the rule of law that the rules be stated in a clear and accessible manner. One of the more important cases in hate speech coming from the Constitutional Court is the Kwelani case. And I will just give a summary of how the Constitutional Court defined hate speech. So we understand from the Constitutional Court, firstly, it says what hate speech is not. So therefore, hate speech is not offensive expression. Hate speech is not discrediting statements, humiliating statements, hurtful statements, offensive statements. Hate speech cannot stifle ideology, belief, or views. It cannot silence disturbing or shocking views. Hate speech cannot violate the rights of others. Then the court goes on to say, what is hate speech? Hate speech is extreme detestation and vilification. It risks discriminatory activities. I will come back to that discriminatory activities. I looked at the Canadian court's definition, and it is very similar to the Kwelani court's definition. The United Nations says that any kind of communication that uses pejorative or discriminatory language will amount to hate speech. But it acknowledges that there is no accepted definition for hate speech globally. So let me go to the Kwelani case again. The Constitutional Court says that hate speech is the detestation or vilification, that the detestation and vilification must amount to making the victim out to be less than human. And therefore, the victim does not qualify for the protection of human rights or the law before the communication can be regarded as hate speech. So to sum this up, the bill is required to translate the constitutional imperatives into practical law. We submit that it does not do that. In fact, it confuses even further. Another section of the bill which is vague and unclear is section 4D. 4D is the religious exclusion. I will deal with the section as it relates to Muslims. This section says that the provisions of subsection 4.1 do not apply in respect of anything done as contemplated in subsection 4.1 if it is done in good faith, in the course of engagement in the bona fide interpretation and proselytizing or espousing of any religious tenet. Simply put, conduct will not amount to hate speech if it is done in good faith, if it is a good faith interpretation of any religious tenet, and conduct will not amount to hate speech if it does not advocate hatred that constitutes incitement to cause harm. I will only look at the bona fide one. This phrase is a Latin equivalent of good faith. This phrase implies that the state apparatuses, the police and the NPA, as well as the courts and other tribunals, will be tasked with deciding what qualifies as a bona fide interpretation of any religious tenet, belief, teaching, doctrine, or writing. This will be unlawful in that it will violate Section 15 of the Constitution, as well as the doctrine of religious non-entanglement. As traversed above, everyone has the freedom of religion. In constitutional terms, this means that everyone has the freedom to choose what to believe in and what not to believe in. In this regard, the Constitutional Court said, as a general matter, the court should not be concerned with questions whether, as a matter of religious doctrine, a particular practice is central to the religion. So, put that differently, the courts should not be concerned with questions whether, as a matter of religious doctrine, a particular practice is a bona fide interpretation of the religion. This is what the Constitutional Court said, and yet this bill says differently. Religion is a matter of faith. The court continues. Believes that the beliefs that believers hold sacred is thus central to their religious faith, may strike non-believers as bizarre, illogical, or irrational. Human beings may freely believe in what they cannot prove. Let me go on to the next section. Regarding the doctrine of non-entanglement, the Supreme Court of Appeal said, a court should refrain from determining the doctrinal issues in order to avoid entanglement. It would thus seem that a proper respect for freedom of religion precludes our courts from pronouncing on matters of religious doctrine, which fall within the exclusive realm of the church. For these reasons, subsection 4.2d, to the extent that it speaks of the good faith and bona fide interpretation, will be unlawful. I want to just speak about another part that comes from the Fourie Court. The Fourie Court is the court that ordered government to legalize homosexual marriage. This court says, these provisions taken together affirm the right of people to self-expression without being forced to subordinate themselves to the cultural and religious norms of others, and highlight the importance of individuals and communities being able to enjoy what has been called the right to be different. The Fourie Court continued and said that in each case that was decided on these constitutional provisions, space has been found for members of communities to depart from a majoritarian norm, and that these provisions collectively and separately acknowledge the rich tapestry constituted by civil society, indicating in particular that language, culture, and religion constitute a strong weave in the overall pattern. The lessons that we learn from the wisdom of our highest court is that South Africa is constituted from a multitude of different colored strands. When they are woven together, they strengthen each other, and all together they make for a formidable nation. However, when this heterogeneity is sacrificed at the altar of a contrived sameness, then the real sacrifice is the very soul of our nation. Every instance in which we dictate to religious persons that they must practice less of their religion, or that they must practice their religion differently in a manner that we decide, that is when we eviscerate the soul from the person. Then, in our overzealous activism to manufacture an egalitarian society, we remove the color from our rainbow. Instead of building a people where everyone respects each other's dignity, our efforts get us nothing except a nation of Frankensteins, a country full of people who are unable to recognize themselves. Instead of having respect for each other, because one built up the other, we hate each other because in order to give to the one, we take from the other. Thank you. Thank you, Mr. Chair.
Thank you very much, Mr. Mohammed, for your presentation on behalf of your organization. Our members, do you have any questions for clarity that you would want to pose? Honorable Smith, I'll start with you.
Thank you, Chairperson. My first question would be in terms of the different wordings that the presenter said is not defined within the bill. I would like to hear in presenter what those definitions will look like if he can present us with the different definitions on all the different words that need to be defined. Thank you.
Honorable Smith, you broke a bit, but I understand that you want him to deal with the definitions of the words he says were not defined in the book. All right. Honorable Dodovu? Mr. Mohammed,
thank you, Honorable Chair.
Okay,
Honorable Chair.
I will, if I could
Mr.
just, if I can,
Mr. Mohammed,
yes.
can you just bear with me for a bit?
Okay.
I'm just taking questions from all the members, and then you can respond after that. Is that okay?
That is good. That is good.
Okay. Honorable Dodovu?
Now, I was saying that Honorable Smith has covered me, specifically the ways that I want the presenter to define in his own way, because he said they are not sufficiently defined or explicitly defined. Among them is harm. The other one is hate. And I think the other one is victim. Thank you, Chair.
Thank you very much.
He can also comment on the issue of the maximum sentence. Thank you.
Okay. Thank you very much, Honorable Mikolakis. I hope I captured Honorable Smith's question as well correctly. He did break out a bit. Honorable Mikolakis.
Thank you very much, Chair. Good afternoon, everyone. Good afternoon, Mr. Mohammed. Just with regards to clause 4.2 of the bill, you spent some time speaking about the exclusion of religious freedom as an act of good faith. The department might say they included, specifically that clause to ensure that they protect the right of freedom of religion. In what way would you say that that clause as it currently stands is not sufficient to protect your freedom of religion? Specifically with regards to the fact that it then, as they would argue, only excludes statements made outside of the place of worship and those made in bad faith. In what way would you say the current clause as it is, based on that, is not sufficient? That would be my first question. Then my second question is, your issue with the bill, is it only with the hate speech part of the bill, or is it also with the hate crimes part? In other words, the whole of the bill. We had a discussion yesterday on from various of the stakeholders where they said that the hate speech part of the bill is necessary. The hate crimes part is necessary. The hate speech part is already covered by other legislation sufficiently. Would you agree with that, or would you say that it's the whole of the bill that is an issue, and why? Also, I didn't hear your opinion, if you have one, on the 8 years maximum sentence for a first offense that they mentioned. So I would like to hear your thoughts if you have any specific comments on that. And the final question that I have for you is, if the bill is then, in your opinion, undesirable in its totality or in part, how would you suggest that, because some of the concerns that were raised from those who feel that the bill is very urgently needed are very valid concerns. It's a fear of being victimized for who they are. How would you propose that we as a society then deal with the issues that specifically, say, for example, the LGBTQI plus community faces in terms of hate crimes and hate speech? If the bill in its totality is undesirable, how should we as a society then ensure that we protect their freedoms as we protect the freedom of religion as well? Thank you.
Thank you, Honorable Mikolakis. All right, over to yourself, Mr. Mohammed, to respond.
Thank you, Ms. Chair, and thank you to the members and for the questions. The issue of the definition, the first question. I must admit that this question is not easily answered. And the Constitutional Court admits this. And the United Nations on this matter also admits the same, that this question of defining what is hate speech is not easily answered. But in my presentation and in our written submissions, we say that the Constitutional Court in the Kwelani case says that you exceed the line of free speech when your speech makes the victim out to be less than human. It makes the victim out to be not entitled to the protection of human rights or the protection of law. That is essentially what I read in the Kwelani case. Now, the reason why there is another manifestation of how difficult it is to define what hate speech is, and that is because over the last 10 years, we've seen a number of cases come before the court, and which some might say that the judgments were strange. And the reason why the judgments were strange is because the courts gave conflicting judgments on hate speech. And in the Kwelani case particularly, the court spends a lot of time on the definition of hate speech. And then right at the end, it just simply says, well, the man is guilty, Mr. Kwelani is guilty of hate speech because of one or two reasons. But it doesn't actually apply the definition that it created itself, that court. And that definition, I say, is the definition that says hate speech crosses the line, or rather free speech crosses the line into hate speech when it makes the victim out to be less than human and not worthy of protection. Regarding the minimum sentencing, I do find that the minimum sentencing is quite heavy. And the reason for that is it is similar to the minimum sentencing for murder and attempted murder. Or I don't practice criminal law, so I'm not so good with sentences.
It's a maximum sentence of 8 years.
It is a
maximum sentence of 8 years.
Of 8 years, yes. So it is similar to the minimum sentence for attempted murder or the minimum sentence for murder. So I don't know, but it appears that we regard hate speech as so abominable that we will equate it to that kind of crime. And I think, given our past, we should rather take a educational role in our sentencing instead of a punitive role in our sentencing, because our communities still have to learn how not to hate each other. And we are not going to teach our communities how not to hate each other by creating more hate. For instance, if an imam gets onto a pulpit and says that in Islam, homosexual conduct is a sin, and such imam have to face court and be sentenced, something like that will create more hatred between our communities instead of bringing us closer together. It will create more of a bully type of conduct by government instead of conciliatory type of conduct by government. Regarding the question of the hate crimes and the hate speech, you will notice in our written comments, we didn't deal with hate crimes because essentially we don't have a problem with the hate crimes section, except for there are two words in the hate crime section which are not sufficiently defined. And those words are pivotal in what constitutes a hate crime. Those words are prejudice and intolerance. Yes, prejudice and intolerance. We don't know what will constitute prejudice or intolerance, or is a simple intolerance, will that amount to a hate crime or not? But those two words are central in the determination of a hate crime. Otherwise, we essentially don't have a problem with that section of the bill. And coming back to the question of section 4.2d, that for us is a huge problem, an absolutely huge problem. And the reason for that is that section 4.1 says that a person will be guilty of a hate crime if he does certain conduct. And then the exclusion under section 4 says that the person will not be guilty of the crimes mentioned in section 4.1 if he does what he does for artistic creativity, performance, or expression. Academic, the B is academic or scientific inquiry. And C says for reporting in the public interest and certain other things. So those are the first three, A, B, and C. But then the exclusion treats religion differently from the first three. The first three are absolute. Those are absolute exclusions. But the religion has a different type of exclusion. Religion says the 4.1 will not apply if the conduct is done in good faith, in the course of engagement in bona fide interpretation and proselytizing or espousing of any religious conviction, tenet, belief, teaching, doctrine, or writings. So the questioner has rightfully said that I spent a lot of time on this. And the reason for that is because who will decide what is a bona fide interpretation of a religious tenet? And the Constitutional Court has already said nobody has the right to decide that except the person himself. The person himself has the right to decide what he believes in and what he does not believe in. The Constitutional Court has also decided that the courts cannot get involved in what constitutes a religious belief or a religious tenet. And here this bill says that the court has the right to decide, or a policeman has the right to decide, or the NPA has the right to decide what is a bona fide interpretation of a religious tenet, or religious belief, or religious teaching, religious doctrine, or religious writings. So the questioner also mentioned the issue of the LGBTQ, and it is well known that many religions believe that homosexual conduct, but let me speak for Muslims, Islam regards homosexual conduct as a sin. So does that mean that from now onwards, Muslims cannot now say so? And I will draw your attention. In June 2022, the Muslim Judicial Council, based in Cape Town, issued a religious edict in which they explained Islam's stance towards homosexual conduct. And a number of articles from NGOs and highly placed academics around the country was placed in newspapers, castigating the Muslim Judicial Council and Islam in general. And in fact, one NGO, a very highly regarded NGO in Cape Town, basically said that Islam is based on archaic law and archaic documents, and they should modernize. This is the type of conduct that Muslims have to deal with. So I don't know which one of the two will be regarded as hate speech. Muslims saying that hate speech or LGBTQ conduct is a sin in Islam, or the NGO telling Muslims that what you believe in is archaic and you should modernize. This is what we had to endure last year, from simply saying what we believe in. But this bill says that the police and the NPA and the courts will have the right to decide what is a bona fide interpretation of the religion. And this is not allowed by the law. So I cannot understand how it can be in the bill. That is the first one is, why is the religious exclusion treated differently from the first three exclusions? The other three exclusions are absolute, except the religious exclusion. And then, right at the end, the religious exclusion says that subsection 4.1 will not apply in respect of anything done if it is done in good faith as a religious tenet, but it still cannot advocate hatred or cause harm. So I don't understand what the exclusion is, because the exclusion excludes a statement that says that it's an exclusion from 4.1, but then it still says as long as it's not what 4.1 says it should be. So for me, that is a circular argument. It contradicts itself. It's an exclusion, and then it excludes from the exclusion. The last words of the sentence excludes the exclusion from the exclusion. And that doesn't make sense. So those are my responses. I don't know whether I clarified it, Ms. Chair.
Yeah, no, thank you very much, Mr. Mohammed, for those responses. They're sufficient. They are your responses. Let me once again thank you for responding to members' questions and for coming to make your presentation to the committee. Our session with you is over for now.
Thank you very much, and thank you to everyone.
Our members, we'll then move on to the next presenter, which is from Cosatu. The presenter is Mr. Matthew Spock. I don't know if he is on the platform. Mr. Fox, you are. Welcome, Mr. Fox, to the session with the Select Committee. Let me thank you and your organization for making your inputs into this bill, as well as agreeing to come and make a presentation to the committee. We'll be giving you 15 minutes to make that presentation, and thereafter members will engage you if they have questions for clarity. And we would prefer that you actually home in on what your issues are with the bill and what your recommendations would be. Over to you, Mr. Parks.
Good afternoon, Chair and members. Thank you for giving us space as Cosatu just to share our views on the bill. We do appreciate it. So we just upload presentation, and I'm sure, Chair, we can even do less than 50 minutes. So, Chair, look, I mean, obviously, as Cosatu, we are part of society. Our members experience hate crimes. They experience, like every other South African, the most brutal hate crimes before 1994 under apartheid. And, you know, workers today, you would see reports and media instances from time to time because maybe they're vulnerable, they're poor, they're women, and so forth. Are real victims of horrific race crimes. We've seen, you know, cleaners at the University of Free State being urinated on. We've seen workers, domestic workers, being physically assaulted. Many other instances. So this is what guides our support for this bill. We think, Chair, it's really long overdue, more so given our history, and that we shouldn't take our history lightly. We think the bill, you know, it will not be a magic wand, but I think it'll be a critical tool in combating hate crimes and hate speech, and even preventing it, because it's going to send us a clear message to society that we won't tolerate certain levels of behavior. And some people will have to pay a consequence for that. Of course, the bill in itself, like any other law, will never be enough. There have to be additional actions, but legislation is helpful, Chair, because it helps to change society's culture, definition of what's acceptable, what's not acceptable. You won't get complete adherence to, and hence the police play a role, but it's necessary. Obviously, because our race is intertwined with the socio-economic issues. Poverty, inequality, unemployment is often linked to the color of your skin or your gender and so forth. So there is a need for additional socio-economic divisions by government, by business, etc., to help to tackle the legacy of discrimination. And whilst we support this progressive bill, we believe there is a need for one further amendment just to further strengthen it, specifically with regard to its provisions dealing with the definition of harm, what constitutes harm. So, Chair, I think, you know, as you said, we support the objectives of the bill because we believe it's a progressive bill. It's going to help strengthen the capacity of the state to prosecute hate crimes and hate speech, which are a reality. We think it's going to also help ensure the legislation dealing with hate crimes and hate speech are in line with the Constitution. And the Constitution is quite clear that all citizens are protected from unfair discrimination. And again, this should not be a shocking matter. Our history of colonialism, of apartheid, are very well known. And the fundamental ethos for those systems of governance was, besides economic exploitation, was about hate crimes, hate speech, brutal discrimination. And we still are witnessing those scars to many degrees. You know, if you look around Cape Town, for example, you can still see the legacies of apartheid spatial planning in a very stark form. Chair, I think also maybe to take a step back, you know, the history of hate crimes and the consequences of hate speech internationally are well known. At times we might take it lightly, say, are we interfering with freedom of speech? We don't think so. And we just simply need to refer to the example of what happened in Rwanda in 1994, how the radio stations were used to mobilize people to commit genocide against the Tutsi minority. We can look at the civil war in the former Yugoslavia in the 90s, where Muslims were persecuted, Bosnians. Entire society was mobilized against each other on an ethnic basis. And of course, you know, the Holocaust in World War II, where Jews, Gypsies, or Roma rather, homosexuals, etc., were literally targeted for genocide, that millions who lost their lives. So we became a democratic state in 1994. We adopted correctly a very progressive constitution, and it specifically says we prohibit unfair discrimination. But we have still seen, Chair, many cases in South Africa of hate speech and hate crimes. At times we take it lightly, but we should be looking at what is the consequence to the victim of these instances, and we should be erring on the side of those victims. We believe that, you know, at times some of these instances have just merely infringed upon an individual's right to dignity. Others, they have been accompanied by violence. So there's another thing we can take lightly. And I think we all got a bit of a wake-up call in July 2021 when we had the violence, mass violence taking place in Gauteng, KwaZulu-Natal, and leave aside the political and the criminal orchestration, the opportunist elements behind it. But there was elements of hate speech too. But it just shows you how combustible society is. A small incident can explode and lead to very serious loss of life, property, and so forth, damage to the country. Chair, now we will obviously refer to the constitutional right to freedom of speech and political beliefs. We always have to make sure we get the right balance between protecting the rights of individuals from harm and, of course, recognizing we have constitutional democracy, we have political freedoms, freedom of speech, and so forth. We think the bill does achieve the correct balance between prohibiting hate speech on one hand and simultaneously recognizing and not infringing unfairly upon the constitutional rights to freedom of speech and political belief. And of course, all rights come with responsibilities as well and limitations at times. We do think that the previous, the bill went through some positive enhancements, cleaning up in the portfolio committee processes. So, for example, they removed the issue of political affiliation or conviction, as well as occupational trade from cover from hate speech, because I think partly providing the balance of freedom of speech. Because we know the chair that political parties during elections, other political engagements would often criticize each other, often very robustly. So you don't want to interfere in that. So I think the revisions to the bill help to avoid that. Trade unions too, chair, are very noisy institutions, very robust. And at times during the process of collective bargaining, of recruitment, of other campaigns, trade unions will insult, will criticize owners and managers of companies. And this is part of the constitutional democracy, but doesn't constitute hate speech. So we think it is correct to kind of ensure the bill didn't conflict with those issues, because you want to kind of provide a right balance between the rights of individuals from protection from hate crimes and also recognizing the right to political expression, freedom of speech, etc. So, Chair, the one area we had thought might need some tightening up. So we support the definition of harm in the bill. What's currently referred to as harm means any emotional, psychological, physical, social, economic harm. And those are fine definitions. But we think, Chair, there's a mistake in the bill where we should have also made reference to cultural harm. The bill does recognize hate speech and hate crimes that impact upon culture, but this isn't carried through as we think it should logically have been done so to the recognition of harm in terms of culture. So to give examples why, so we believe the harm personal community can suffer, do suffer often from hate speech and hate crimes can materialize culturally as well. We will recall an incident in Cape Town a few years ago on a beach, I think Camps Bay, where people were insulting African culture for wanting to sacrifice cattle there and so forth. Sure, that might have violated some bylaws, but I think it highlighted the point that at times people can go a bit too far when they criticize each other, more especially when they criticize cultural practices. We also saw, Chair, shamefully to all of us, a similar prevention of Muslim communities carrying out religious or cultural practices. So a few years ago, we saw that the call to prayer by the mosque became a rallying point for residents of Centurion who mobilized against it. And Chair, that obviously causes significant psychological, cultural harm to those individuals, to those communities. And we've seen a very strong linkage between hate speech and mobilization against cultural practices. And this has a significant impact upon those communities. Yes, you could say it harms them psychologically, socially, and so forth, but also there is a cultural impact too. If a Muslim community in Centurion is not able to go to pray in peace, that's a cultural harm to that community. Similarly, African communities can't exercise their cultural traditions. Equally, that would also qualify. So our proposal, Chair, is simply to insert the word cultural in the definitions of harm. So just insert it after social and before economic harm in the definition of harm in clause 1 of the bill. We think that will then help to ensure the bill provides a full scope of coverage and intent and so forth. And I think also make a message to society as well that people should respect each other's culture and religious traditions and needs and so forth. So in conclusion, Chair, what it says, Cosatu, we do support this bill. We support its speedy passage by Parliament. We look forward to being enacted into law before the end of this administration. It's been a long journey for it to reach this stage. We think it's going to play a positive role in empowering the state to tackle such crimes and also to protecting all citizens' rights, especially the most vulnerable. We think it's in line with and gives expression to the objectives of the Constitution and the Bill of Rights in terms of preventing unfair discrimination. We think it does provide a fair balance of the rights of citizens in terms of freedom of expression, freedom of speech, political views, etc. And these always have to be balanced with other people's rights as well. We think, though, as we just said, Chair, the bill does need to be strengthened simply to recognize the harm hate speech and hate crimes can do to citizens' cultural rights. So, Chair, lastly, we look forward to this bill's passage, and of course, it will mean a significant amount of work by the Department of Justice to empower the courts, by the police service to train police officers, also by our schools or universities to educate children, students, learners, the public broadcaster, SABC, because we can have very good laws, but we need to make sure that society understands them, is aware of their rights and responsibilities, because government can do so much. We all have a responsibility to assist government in implementing these laws and really make South Africa, Chair, as the Freedom Charter said, a country which belongs to all who live in it, black and white. But thanks very much, Chair, and hope I stuck to the time. Thank you, Chair, members.
Thank you very much, Mr. Matthias Parks, for your presentation on behalf of Cosatu. Honourable members, do you have any questions for clarity? Honourable Dovu? Okay, Honourable Dovu.
Thank you very much, Honourable Chair. Let me take this opportunity to thank the presenter for his presentation. Just some few questions from my side. The first one, do I understand the presenter to say, if he says that the definition of harm must be expanded to incorporate the cultural harm, is that the firm proposal that he's putting on the table, or is there any other expansion that he would want to elaborate on in respect of his proposal? That is one. Two, there are some critics who say this bill as it stands will not pass the constitutional muster, precisely because it encroaches on the Section 38 clause of the Constitution, which deals with the limitation of rights. What is the view of Cosatu in respect of that? The third one, Honourable Chair, relates to justice. There are forms of justice that other people are proposing. One is retributive justice. Of course, this is the one you're talking about, that those who perpetuate hate crime or hate speech must be punished, and they are offending other citizens of the country. But the other justice that people talk about is restorative justice, where in which the perpetrator and the victim can be set down, engaged, and so on and so forth. What is the view of Cosatu in relation to that, but also on the fact that the privileged people in this country must support this initiative in order to ensure that there is redistribution of wealth and resources to the people? What is the view of Cosatu in terms of that? And lastly, Honourable Chair, what is the view of Cosatu in respect of the maximum sentence of 8 years? Thank you very much.
Thank you very much, Honourable Dovu. Honourable Badenhorst.
Okay, thank you very much, and good afternoon. Thank you, Mr. Parks, for your input into this bill. It's much appreciated. I've just got one question, if I may. You concentrated quite a bit on the element of harm, and you've made a suggested insertion into that specific element. There is another element to this bill which is quite important, and that's the element of hate. And many of the previous presenters that we've had over the past 2 days have brought it to our attention that the bill wishes to criminalize hate speech, but it fails to actually define hate or hatred. So that becomes problematic in the sense that if Parliament is then the legislator and needs to pass the bill, it would then applicate its responsibility to the courts to decide what hate would then be, or what a hateful action would be. it also then makes this bill very unclear to members of the public, who would then not know when they are breaking it in the absence of a clear definition of hatred. So I'd just like to get your opinion on that absence of a definition of hatred. Thank you very much, sir.
Thank you very much, Honourable Badenhorst. Honourable Smith.
Thank you, Chairperson. Honourable Chair, my question to Mr. Parks is, in terms of the insertion that he suggests on cultural harm, how would he say, it be balanced between, different culture, because what will be harmful towards one culture might not be harmful to other, and that, what one culture maybe believes in, for example, the slaughtering of animals on the beach, as he mentioned, will be harmful to another culture, emotionally so, and so forth. So how do one balance those two? And then also relating to that specific point is in terms of where does he see the line between being offensive towards a culture because you've got a different view about the culture, and being harmful in so that it actually translates to hate speech and pronouncing on that. So I would like to hear his view on that specific points. Thank you.
Thank you very much, Honourable Smith. Mr. Parks, over to you.
Thanks to Chair, and thanks honourable members. I think the questions are really helpful and positive. So I think it indicates to me that we're all kind of recognizing this is the challenge that collectively we all are facing. We all have to try to address in a common sense way. We appreciate it's not an easy thing. It's not an easy thing to kind of guide what people say. You have to try to get the right balance. So, Chair, I think to Honourable Dodovu, look, and I think even to Honourable Badenhorst as well, and Smith, we think it's important to include culture in terms of harm, because it speaks to economic harm, social harm, psychological, and so forth. And all of them have valid instances that you might have suffered as a society, as a community, as an individual. But we just thought that there is a need to include cultural harm. We appreciate that a bill can't be open-ended and cover a million things. But I think given the strong linkage between culture and identity, language group, racial group, the history of South Africa, there is a need to do so. South Africa deliberately for many, many decades instituted harm to communities based on a cultural preface. And sadly, that hasn't completely ended post-1994. Obviously not at the same level, obviously, but the instances, Chair, that you would find in the example I mentioned about Centurion, where Muslim families in Centurion were being harassed because the mosque was calling into prayer. So we think those are the kind of examples. Chair, I think also just honourable Dodovu around, would it pass constitutional muster? We think it would, definitely. We assume that the Chief State Law Advisor has given the constitutional certificate beforehand, and the parliamentary legal advisors likewise. But Chair, look, on the principal issue, so the Constitution isn't a blank check. Yes, everyone has rights, but all rights come with responsibilities. So yes, the right to freedom of speech, that's a very critical right. It shouldn't be tampered with lightly, but there's limitations. So for example, you can't go to a crowded cinema and shout fire, to use that common example, because there's a risk now to people stampede, people might die. And one could simply say, well, I just expressed my views, and it's not a crime to be an idiot. But in that instance, there could have been lethal consequences to it. So I think a police officer, a judge, in any instance, or the prosecutors would have to weigh up. Was it just simply a question of me being drunk at a braai and being obnoxious? Or what is the impact also to society? And I think that's also why in the sentencing provisions, it says up to 8 years. So the law enforcement institutions would have to weigh up what is the damage, what is the intent, what is the offense, and so forth. We appreciate it's not going to be an easy thing. It's not as clear-cut, for example, as assault or theft. But nonetheless, it is a significant thing. And I think also, Chair, if we don't deal with it in society, there can be a dangerous consequence which can be much more harmful. If we allow a society where people insult each other on Facebook based upon racial groups, across political tendency, that can get out of control and it can create real issues. We're not that far away from it at times, sadly. I think we had seen instances during July 2021 in Durban at times. So we think the Constitutional Court would look at, is discrimination allowed? And they would say no. They would say, do you have a right to dignity? And the court would say, yes, you do. The Constitution also compels the state, the legislature, to use legislation, etc., to advance the cause of equity and equality, look at the issue of redress for historical issues. And of course, there are limits to all rights and responsibilities, and that's the international legal precedents. Chair, I think in terms of the sanctions and so forth, look, you don't want to fill prisons with people. Ideally, you would rather go the restorative route, warning, counseling, etc. But for those who really commit significant offenses, you'd have to do something. You would have to make a few examples of a few people to punish them, to send a message to society that there are certain things which you can't tolerate as a society. There's a need to change. And one should not place the rights of an individual to be offensive upon the rights of society to dignity. We have to respect other people's rights. Even if we have different beliefs, we might have different religions, etc. We should be respectful to each other's religions. And there's enough space in a democracy for us to do so. We shouldn't be going the route what at times you'll find in some European countries where they want to interfere with how, for example, Muslim girls or women might want to dress or need to dress, etc. I mean, Honorable Dodova is right. I mean, you don't want to have everybody going to prison, but obviously when the matter is serious enough, the intent is serious enough, then sure, that must be the route. But ideally, you want to go the route of restorative justice where possible. You want to change culture. You want to make sure our educational institutions help guide society in the right direction. And of course, you know, as parents, we also have an obligation to raise our children correctly, to embrace each other. And Honorable Dodova is right. We have to address the socio-economic divisions in society because the fact that you have a wealthy suburb like Constantia, overwhelmingly white, a poor colored working class community like Manenberg, and a poor working class African community like Khayelitsha. And all the socio-economic, the poverty, the unemployment, the gender-based violence, the crimes, etc., hit the poor proportionally harder, and obviously hit people who are African and colored, working class women the hardest. So we have to address that because these things will just address it on a superficial level. The fundamental issue is how do we build a non-racial society in our economy, etc. And that's, I think, sadly, it's going to take quite a long time. But we do think that the 8-year sentencing is appropriate because it goes up to 8 years. So obviously, the prosecutor, the magistrate must choose what is appropriate, what was the level of the offense, what was the intention, what was the impact, etc. We were concerned in the first draft of the bill that we felt the sentencing was a little bit too light when it then talked about, I think, 3 to 5 years. And we think we shouldn't take hate crimes or hate speech lightly. If someone dies as a consequence, there was someone like in the case of Rwanda, the people on the radio stations, they didn't kill anybody themselves, perhaps, but they mobilized society through hate speech to go and kill 1 million people in 90 days. I think to Honorable Bodenhorst, in terms of the definition of hate, I mean, if I read it correctly, I think sections 3 and 4 speak to the definition of the offensive hate crime, the offensive hate speech. I think it does go into a fair bit of detail, and obviously I think it links to the issue of harm. So I would believe that those are sufficient. But if the members think that they need to strengthen it further, but we had felt that it was sufficient in terms of defining what is a hate crime and what is hate speech, and linking it to the definitions of discrimination and harm and so forth. To Honorable Smith, look, we do appreciate it's a difficult thing. It's not an easy thing. People have different religions, different values, etc. But we need to be sensitive to each other. We should be sensitive to people of different ethnic groups and religion. And I think there's a bit of a need for a legal framework to guide what is acceptable, what is not acceptable. If we just simply leave it as a blank slate and people can choose how they want to do it, then things get out of control. Then you will find people attacking people because they're Muslim, because they're Jewish, or whatever the instance might be. And that's going to cause problem. That's going to cause conflict. So I think it's about how to try to prevent it, as the title of the bill says, how to try to promote education, etc. But I think it shows, the instance of the cow on the beach in Cape Town, the call to prayer in Centurion, etc. Many other instances. I think we've seen the issue of the swimming pool incident in Bloemfontein. I think it was last year, January. All of this shows you that we're sitting on a ticking time bomb, and there is a need for us to be much more comprehensive and give a very clear legal guidelines to the police, to prosecutors, to society. Because also it's difficult for the police. You would come to them as a parent if your child has been assaulted because of the color of the skin, and the police might say, well, is that a crime? Is freedom of speech a crime? Yes, he was offensive, he insulted you, but what's a crime? So here we're now going to assist the police to say, on these are the types of incidents which are a crime. This is how you define them, how you deal with them. Same thing with the National Prosecuting Authority, same thing with the judges, because they can't just charge or prosecute or convict based upon feelings. They have to do so based upon law. And now we're going to have a law to say, here's how you manage these instances. But I think, of course, the police, the NPA, the judges will always have to weigh up what is the intention. Was a person just being an idiot and drunk at a braai? Do they intend to mobilize society? What is the harm to the person? Do they humiliate the cleaner at the University of the Free State? What are the consequences to society? Because obviously, if you mobilize people to engage in violence, they must be hit with heavy consequences. So I think for us, it provides the right balance. It's not an easy balance to do so, but we are confident this one does provide the correct balance in a very sensitive, very complicated issue. And I think in the longer run, it'll help move us in the correct directions as a society. It might be a bit of a learning curve for the first year, 2 years, but I think in the end, we'll be better off for it. And we're not alone in the world going through this journey. I think many other countries have gone through similar journeys, and they've shown it's correct that you need to deal with such issues and not take it too lightly as a consequence, whether it's Rwanda or Israel, many other countries. So I think this is a positive step in the right direction. But yeah, hopefully I answered the questions and did justice to the members' question. Thanks very much, Chair, members.
Thank you very much, Mr. Parks, for your response to members' questions. We've come to the end of our session with you. Thank you. Members, we move then on to the next presentation by Gender Diversity Coalition. We have Max Belinda, who I'm told will be making the presentation. Ma'am, are you okay? I see you are on the platform. Maybe can you confirm that you're on the platform?
Good afternoon. I am on the platform. Can you hear me?
Yes, yes. Let me welcome you once again to this meeting, and also thank you for your submission that you've made on the hate crimes, hate speech bill, as well as today making the presentation to the committee. We'll be giving you 15 minutes to make your presentation, and thereafter members will interact or ask you questions for clarity. And we prefer that you focus on what your issues are with the bill, as well as what your recommendations are. Over to you.
Thank you so much. Am I able to share my screen?
Gershwin, can you? Okay, yes, you can.
Can you see it?
No, not yet. Though we do have your written submission, if you wish to speak to it, it's also fine with us.
Okay. So it seems like I'm struggling to share my presentation, so I'll just speak to the submission, and I'll take it from there.
Please continue.
Good afternoon, Chair members. I would like to greet you and also thank you for this opportunity to comment orally on the prevention and combating of hate crimes and hate speech bill. My name is Belinda Kakamba. I am part of the National Gender Diversity Coalition, and today I'll be representing the voice of the National Coalition. My pronouns are they and them. So my presentation will give a brief background on the National Gender Diversity Coalition as a recognized body in South Africa, the positionality of the coalition with regards to the bill, also shed light on some empirical evidence that affect the realities of the community we are serving, and our concerns, and further a brief conclusion with regards to that. So established in 2019, the National Gender Diversity Coalition is a coalition of organizations working in trans, gender diverse, and intersex communities. It consists of 11 SOGIESC-specific organizations and 3 legal partners, making it a total of 14 civil society organizations that are positioned all across South Africa. The aim of the collective is really to provide strategic leadership and direction to ensure the advancement of legal and social recognition of trans and gender diverse persons in South Africa and beyond. The focus of the coalition is really much on bodily autonomy, self-actualization, self-determination for transgender persons, gender diverse persons, intersex persons under the jurisdiction of the Republic of South Africa. So as the coalition, we really welcome the opportunity by the NCOP to orally comment on the bill. We deem hate crimes and hate crimes legislation as fundamental to protect trans, gender diverse, and intersex persons in South Africa. However, we also acknowledge here that the bill is the necessary foundation that is needed, but there must be also a multifaceted approach in tackling the roots of hate and ultimately transform society. So as trans and gender diverse persons and ultimately intersex persons in South Africa, we are faced with daily threats of transphobic, intersex phobic, and other hate crimes and hate speech that are really directed to the community and to its individuals. These crimes range from harmful hate speech and often escalate and has the potential to escalate to violent abuse, rape, assault, and murder. These are crimes that are really motivated to dehumanize and erase gender minority groups. The realities of trans and gender diverse and intersex persons in South Africa, like elsewhere in the world, is characterized by a face of violence, discrimination, trans and intersex antagonism. We are constant victims of hate that manifest covertly and overtly through hate speech, with pejorative language that seeks to dehumanize, erase, and disparage our identities. This verbal dehumanization is further explored through violent crimes ranging from physical abuse, rape, assault, and murder. There is also empirical evidence that we've done from our, that comes out of various organizations. And this empirical evidence shows the extent of this violence and how it manifests and how it's directed to our communities. The Batselo-Batrans study on transgender women reveals that violence in 3 South African cities, Buffalo City, Cape Town, and Johannesburg. And it really shows the gross human rights violation on transgender women, especially transgender women who are on a street base and living as on survival sex work. The Trans Rural Narratives is another research study by Gender Dynamics and endorsed by various other organizations that shows corrective rape prevail, and this phenomenon really being duplicated into the lives of transgender persons, where curative rape is found happening to transgender and queer individuals in rural and semi-rural communities. And it also reveals how these cases are often goes undocumented. The REACT annual report, human rights report, reveals 58% of the reported cases were perpetuated by law and police officials on vulnerable Black, poor, street-based, gender-diverse persons. And then another study that we've done with the Lawyers for Human Rights called Breaking Borders and Binaries shows that the intersection of violence with regards to gendered transgender persons who are asylum seekers and refugees, really showcasing the intersection of transphobia, intersex phobia, and xenophobia. So, as the coalition, we fully support this bill. We further ask that this bill not be longer prolonged, and that it must really start to take effect so that these crimes can really be dealt with through legislation. We also note the dogmatic wave of the anti-gender movement that is coming from the global north and really spilling across South Africa. And these spills really threaten gender and sexual minorities in this country. We therefore call on the NCOP to really fasten the process in protecting transgender persons in South Africa, intersex persons in South Africa, and ultimately gender diverse persons in South Africa. Thank you so much, Chair. I'll give over to you.
Thank you very much, Max. Belinda, how did you say you pronounce your surname?
It's Katamba.
Okay. No, thank you very much for your presentation. Our members, do you have any questions for clarity? Honorable Dodovu.
Thank you very much, Honorable Chair. Firstly, let us welcome the presentation. I think the presenter was very much eloquent, very much clear, and her bottom line is quite understandable. Now, my question is that the presenter says they welcome the bill. It must be fast-tracked, it must be expedited. But there are two issues that I'm picking up. Firstly is that those who transgress, there is a maximum sentence of 8 years. What is the comment of the presenter on that? And secondly, as she's saying she is, or I apologize, as the presenter says, represent about 14 organizations. These organizations are national. Are they found in all the provinces in South Africa? And if there are those who want to reach out to you, how do you facilitate that particular process? Thank you very much.
Thank you very much, Honorable Dodovu. Over to you, Max Belinda.
So I will answer the second question first, and then I'll come back to the first question. So the 14 organizations that forms part of the Gender Diversity Coalition, as I said, they are associate-specific organizations, and they come from all across South Africa. In example, Triangle Project is based in Cape Town with Gender Dynamics. Trans Hope is based in Durban with Same Love Toti, also based in Durban, Utingo, also based in Durban, and we have the Johannesburg-based organizations, Iranti, Matima, Be True to Me, Access Chapter 2. Trans Wellness is an organization that does rural work on rural transgender persons. So there's really a widespread associates organizations that are widespread in South Africa. And then we have legal partners that we work with that form part of the coalition. And those organizations, the Legal Resource Center, Lawyers for Human Rights, and the Women's Legal Center. So these organizations then provide that technical support to the Gender Diversity Coalition. So some of the organizations within the Gender Diversity Coalition provide direct services to transgender persons. Some of them document human rights violations, and some of them really provide more system level change within South Africa. So they're all South African based organizations.
Yeah, the other question was with regard to the maximum sentence of 8 years.
So the other question was regard to the maximum sentence of being 8 years. As I've stated, that as the National Gender Diversity Coalition, we support the contents of the bill. We have read, we understood the bill, we support the bill as it stands. And we are really asking for this process to be fast-tracked, not for important and nuances to be undermined, but to be fast-tracked because we understand as well that there's lives at stake, and we want it to be looked at from that vantage point. So we welcome the 8 years that is being set as a maximum prison sentence.
Okay, thank you very much for responding to members' question, and let me also thank your organization for making an input into this bill. We've come to the end of our session with you. Thank you.
Thank you so much.
Our members, we'll move to the next presenter. I think members will note that there was a slight error in terms of the times on the schedule, the notice that was sent out to you. Our next presenter would be Media Monitoring Africa, Mr. William Bird. I'm not sure if Mr. Bird is on the platform. Gershwin, I need your guidance here.
Hello, ma'am, may I speak? It's William Bird.
Oh, Mr. Bird. Okay. Let me welcome you to.
I'm here, but sorry, just to interrupt. I'm still waiting for our actual speaker, Ben Winks, to join us. He will be with us any moment. So while I and my colleague are here, we're not ready just yet to present. You'll hopefully be with us in the next 3 minutes or so.
No, it's quite understandable. My apologies. I think we communicated a time to you. Yeah, we kind of made a mistake with the time on the schedule. My apologies, but it's understandable. And if it would be okay, honorable members, I want to just verify whether the Association of Christian Media is on the platform. Mr. Philip Rosenthal, are you on the platform? Mr. Rosenthal. Okay. Okay. All right. All right. And then is Lita Labantu on the platform? No. Okay, members, can I propose we take a 10-minute break? It's 3:20 according to the clock in front of me.
Sorry, Madam Speaker.
Yes.
Sorry to interrupt again. It's William Bird. I see Advocate Ben Winks has just joined us. So if you would like, we can, or you can take your 10-minute pause, or I believe that we should be ready. I'll just check with him. I see he's in the meeting now. He's there.
Yeah, let us, members, let us take the 10-minute pause. You can grab something to drink, stretch your legs. Someone said yesterday you can also go for a smoke break if you wish. Yes, 10 minutes at 3:30. We'll then continue.
Recording stopped. Recording in progress.
Honourable members, I hope you're back. I think we'll then proceed if Mr. Bird, William Bird, are you and your colleague ready to proceed?
Hello, good afternoon. Yes, indeed, we are.
Your colleague's name is?
Advocate Ben Winks.
Advocate Winks. Okay. Now, let me take this opportunity as well to welcome you to this meeting and thank you for your written submission as well as the fact that you've agreed to come and make an oral submission to the committee. We'll give you 15 minutes and we'll questions of clarity if they have. And we would prefer that you stick to what your issues are with the bill and what your recommendations are. Over to yourself, Mr. Bird.
Thank you very much, and thank you to the committee for this opportunity. So I'm William Bird. I'm the Director of Media Monitoring Africa. We are an NGO that has been running since 1993. Part of our work has been making submissions to parliaments, to various other bodies, including other Chapter 9 institutions, South African Human Rights Commission, ICASA, and more regularly to Parliament's Portfolio Committee on Communications. And one of the issues that we've been working on over the years has been the issue of hate speech, dealing with hate speech online. We currently have an agreement with the South African Human Rights Commission to help them combat hate speech online and mitigate its awful impacts. I'm going to now introduce Advocate Ben Winks, who's a hate speech specialist. He has been working with us on our submissions, and I'm going to ask him if he would be so kind as to highlight the key points that we have made. He has been fully briefed on the requests to keep it short and sharp. Thank you. Over to you, Ben.
Thank you very much, William, and good afternoon to the chair and the honourable members. Thanks very much for giving us the opportunity to make these submissions. You would have seen from our written submissions that the essential issues with the bill that MMA has concerns about are around the hate speech chapter rather than the hate crimes chapter. There are some recommendations made there, but we'll focus these submissions on the hate speech chapter. Now, the main concern that MMA has is that the current formulation of the crime of hate speech is one that will probably invite a constitutional challenge, and the constitutional challenge will probably be successful in light of certain aspects of the Kwelane judgment and some international law. Now, before I go into why, I'm just going to preface what we say by emphasizing that MMA does believe there is a need to prohibit, deter, and punish extreme hate speech, the kind of hate speech that's described in the International Covenant on Civil and Political Rights and the Constitution of our country as speech that advocates hatred on grounds of group identity, which constitutes incitement to cause harm. So it's where speech becomes incitement to cause harm based on prohibited grounds that criminal law ought to step in and prohibit, deter, punish, rehabilitate. Short of incitement, you then get into the realm where, as the members will know, then you're outside the 16(2) exception to the right to freedom of expression in the Constitution. And then Parliament needs to justify every limitation it imposes on free speech beyond that, beyond incitement based on prohibited grounds, incitement to harm. So the every step that Parliament takes into that realm of non-insightful speech is one that has to be justified carefully and balanced against the right to freedom of expression. Now, obviously, the interests to be served are the interests of equality and dignity, which are profoundly important interests, which the Constitution not only empowers but enjoins Parliament to protect and promote. The question then is whether there are less restrictive means which would make it disproportionate to criminalize certain forms of speech. Now, the way the bill currently defines criminal hate speech is essentially in the same way as the Equality Act provides for the civil prohibition or delict of hate speech. So it's criminalizing essentially something that's already prohibited in civil law. Now, there's in principle, when you're dealing with other crimes, there's not necessarily something wrong with that. So assault gives rise to a civil delict, a civil cause of action for damages, etc. But it's also a crime. And the same goes for a wrongful death, which can be murder or culpable homicide. But in international law, what the African Union and the United Nations Committee on Human Rights and several African courts have held is that where you're dealing with free speech, it is more vulnerable to a chilling effect than, for example, the freedom to wield fists and firearms. Where you're dealing with speech, you have to be a lot more careful about imposing criminal as opposed to civil prohibitions. So what's been held in the context of criminal defamation is that where there is a civil delict of defamation, it is excessive and therefore unconstitutional and disproportionate and therefore unconstitutional to criminalize the same thing that's already the subject of a civil prohibition. And that's because of the unique chilling effect on free speech. And the practical concern that MMA has is that, and one can see examples of this in the way that even the civil prohibition is approached, is that when a criminal prohibition is created, it places a potent weapon in the hands of agents against transformation, agents against racial justice, gender justice, to use that criminal prohibition against activists for change. So you will have, for example, you have activists for racial justice who may use very confrontational terms about white people. There was an artist, for example, who had an installation which used the phrase "F white people" numerous times. That was taken to the Equality Court, and ultimately they were successful, not the complainant, but the artist was successful in a very well-reasoned judgment in the Cape Town Equality Court. But if there was a criminal prohibition, you would have had this person subjected to a police investigation, fingerprinting, potentially prosecution, and even imprisonment for essentially expressing frustration with white supremacy, with confronting white supremacy. And the same could go for people confronting patriarchy and homophobia and xenophobia, that they could then be subjected to criminal investigation and prosecution for essentially activities which are equality promoting rather than equality retarding. And that is the risk when you criminalize something as opposed to having it under an equality law statute where it has civil liability. The next concern that we have is that the current definition appears to extend the prohibition into private communications. Now, the Constitutional Court in the Kwelane case was fairly lucid about why this shouldn't be the case. And the Constitutional Court cautioned that even the civil prohibition should not be subject to a prohibition on, even a civil prohibition shouldn't extend to private communications. So what the Constitutional said was that hate speech prohibitions, even those that attach civil liability, should not extend to private communications because that would be incongruent with the very purpose of regulating hate speech. That public hateful expression undermines the target group's dignity, social standing, and assurance against exclusion, hostility, discrimination, and violence. Now, in the couple of minutes remaining, we should obviously say something helpful rather than what could perhaps be a recommendation or a remedy to the concern that we have. and that is to replicate the language of Section 16(2)(c) of the Constitution, which is advocacy of hatred on only 4 protected grounds are mentioned there, but it should be extended to all of the protected grounds mentioned in the Act, including albinism, HIV status, and disability, etc., sexual orientation, so that advocacy of hatred based on any of the prohibited grounds, which constitutes incitement to cause harm, should be an offense. That both of those elements must be there. But the current prohibition in the bill goes far beyond that. It will therefore need to pass the limitations test. We don't believe it will pass the limitations test because there are less restrictive measures available and already in place, and it's therefore excessive. You would have seen in our submission, we've also referred to other area law that overlap with hate speech, especially the Films and Publications Act, which comprehensively criminalizes hate speech. Now, the constitutionality of that provision is a little suspect, but the point is that it's excessive to criminalize something that's already dealt with in various other laws. Now, the other, I think I have 1 minute left before questions. The other possible suggestion to ameliorate any concerns that you have is that crimen injuria is already a crime. It's the crime of seriously injuring someone's dignity or privacy. And many hate speech cases have also been prosecuted as crimen injuria cases. So the hate crime chapter would already cover hate speech in that case, because crimen injuria on the basis or motivated by prohibited grounds, motivated by prejudice on prohibited grounds, would then be hateful crimen injuria. It would be the hate crime of crimen injuria under the hate crimes chapter. So that would solve the problem. So one option is to take out the hate speech chapter altogether. That's perhaps an unrealistic one. The other one is to narrow the hate speech prohibition to the language of Section 16(2)(c) of the Constitution. I hope that's helpful, and we're very happy to answer any questions you may have.
Thank you very much, Advocate Winks and Mr. Bird, for your presentation. Our members, do you have any questions for clarity? Mikolakis?
Thank you. Oh, sorry, Chair. Thank you, Chair. Good afternoon. Good afternoon, Mr. Winks. My question is just with regards to the definition. We heard yesterday from some of the stakeholders saying that hate is a concept that cannot be defined in law. Would you agree with that? And if not, what would you suggest would be an appropriate definition for hate? Because currently that element of the crime is not defined, and it is quite worrying for obvious reasons. Then the second question I have is that Professor Madonsela, I think on the first day, said that in her view, harm should be defined as broadly as possible. And then it should be left to the courts to flesh it out. What would your opinion be? Would you agree with her, or if you disagree with her, what would your arguments be for saying that it should not be as widely defined as possible? I don't agree with her, but I would like to hear what your reasons are if you disagree with her. Also, another interesting argument that we heard, which I would like your opinion on, is that if you exempt those who adhere to certain religious views in terms of the clause 4(2) of the bill as it currently is, then it's unconstitutional on the basis that you afford a right to religious groups that you would not afford to non-believers. So the religious are exempt from certain forms of hate crimes and hate speech, which is a right that you are not affording to those who don't adhere to it. I thought it was a very interesting argument. that on that basis, that exemption is unconstitutional. And because I found it such an interesting argument, I would like to also, perhaps I know it's not part of your submissions, but I would like to hear your views. Can it be argued that you cannot allow such a submission or such an exemption only to persons who adhere to some form of religion? And then finally, I just would like to hear your views on the 8 years maximum sentence for first offence. It started in the National Assembly initially as 3 years, as introduced by the department, and then it was increased to 8 years. We heard yesterday that in terms of other legislation, it is 2 years in some instances, in some existing laws. And I would very much like to hear what you think, if the bill would pass in its current form or with minor amendments, what you would think would be reasonable and the reasons for saying that. Thank you very much.
Thank you very much, Honorable Mikolakis. Any other member? If not, just to add to what the questions that you've been asked, you say that you monitor hate speech online and you mitigate in terms of its impacts. But can maybe just speak to us in terms of how do you determine that it's hate speech online? I mean, what framework, legal framework, or anything that you're using? I want more the details on that. Thank you. Over to yourself, Advocate Wink. Or okay, you'll sort yourself out.
Yeah, thank you very much, Chair. I'll just answer Honourable Michalakis's questions, and then the more practical question that you've posed, Chair, I think Mr. Bird will be more well placed to speak about the actual mechanisms that MMA uses to identify and report hate speech. So the first question, the submission was made that hate can't be defined. I don't agree, because the Constitutional Court has defined it. In Kwelane, many paragraphs are devoted to defining what is hatred, and the Constitutional Court takes a great deal of information, in particular from the Canadian jurisprudence, where hatred is defined as extreme ill will, detestation, and vilification. And then the Constitutional Court in Kwelane then applied those concepts to the article that had been published by the late John Kwelane, and found that it met those descriptions. It's impossible to define every term to exhaustion, to cover every possible thing that might be hateful or might not be hateful. We do have to, I mean, respectfully, I think Parliament does have to trust the citizens and the courts to interpret laws reasonably. And the term hatred, I think, is capable of legal definition. In international law, there's books that have been written about it. And I think it's more a philosophical question of, what is hate, rather than a legal question, because in the law, we do have definitions for it. The equality courts have been applying it for years without a great deal of difficulty. The more difficult question is usually determining what the objective meaning of a particular thing is, rather than, once you've determined the meaning, whether that meaning is hateful. If it degrades people's human dignity and equality, then it's hateful. That's my sort of shorthand definition. And I think the Constitutional Court authorities are fairly consistent with that. But Kwelane is the place to look for the definition. Harm ought to be defined widely. I think that the Constitutional Court, and also in international law, the position's been taken that harm shouldn't be restricted to physical violence. The clue for that is in Section 16.2 of the Constitution itself, because Section 16.2b speaks about free speech not extending to incitement of imminent violence, and then C is about incitement or advocacy of hatred that constitutes incitement to cause harm. So there's a distinction there between harm and violence being obviously a broader concept. And the Constitutional Court held that harm should extend to serious emotional and psychological harm. So you would have obviously the de minimis rule that the law doesn't concern itself with trivialities. So if it's a trifling degree of harm that, people are being oversensitive and a reasonable person wouldn't feel harmed, then that's of course covered by the existing framework of the definition in the Equality Act, that, a reasonable person would find it to be harmful. So I wouldn't take it any further than that it does extend beyond physical harm to serious emotional and psychological harm. I don't think it's necessary to try and define it in any more detail than that. As for the religious exemption, as you said, it falls outside MMA's scope, and William will correct me if I step out of line, but I personally don't like the exemption. I do think it's potentially discriminatory. I understand why it's been included. It's been included because otherwise the Bible could be criminal hate speech, among other religious texts. I think I'd have to give a lot more careful consideration before I offered a view on whether it's necessarily unconstitutional, but I do think there is a risk that it's discriminatory, whether it's a justifiable discrimination based on the extent and depth of belief in the country. That's probably something Parliament would be given some latitude to consider, but it's definitely an issue that needs to be considered. Then the maximum sentence, I think 8 years is manifestly excessive. In comparative countries, you see usually something like 2 years. In Europe, you do get quite serious sentences in some cases for Holocaust denial, and that's obviously because, and for promoting Nazism or other fascist organizations. That's obviously because of their history. But I think lessons have been learned since then about the unique chilling effect on speech of these heavy sentences. So I'd implore you to look at the case of Lone Issa Konate, that's Konate, versus Burkina Faso in the African Court of Human and People's Rights. I think it was in 2014 or 2015 the case was decided, where they referred to a number of international authorities and found that excessive custodial sentences are generally not necessary to combat harmful speech, and that non-custodial sentences like fines or other forms of rehabilitation should rather be ordered. I think that, I mean, they do say that for extreme hate speech, different considerations may apply, but I think as a general proposition, speech being something that doesn't endanger necessarily people physically, I think unless it rises to an incitement of violence, I think you're on dangerous territory imposing custodial sentences. William, sorry about the chair's question.
Thanks. I completely agree with those answers. So in terms of practically what we do, so we run a platform called Real 411, which is a public complaints platform. That's we built it for the elections in 2019, and in fact it'll be running again, and it's been running since then. And we added hate speech as an additional online harm because it was originally looking at mis and disinformation. And the way that we deal with it is that we use the criteria that were defined by the Court to determine whether or not something constitutes hate speech. So we will look at that and see if, in our view, and the view of 3 reviewers and then a member of the Secretariat, they believe that that is hate speech. It then gets sent to the South African Human Rights Commission for them to determine whether or not they wish to then launch an investigation or do whatever other action the South African Human Rights Commission sees fit to act on in that regard. But in essence, in practical terms, the criteria are set out, and I'll send through a link to Gershwin just after this to the platform, and I'll include a screen grab of where we show the precise criteria that are used in assessing it. It is because we've got a very high threshold, and we think appropriately so. What we tend to find is that very often you'll find speech contains elements of hate speech, so they may be particularly offensive and vile, but they may not constitute incitement, for example, directly. So we're finding elements where they meet certain criteria, but not as commonly that they are actually overtly hate speech. And the reason we're using that definition is because it's in line with our constitutional court ruling, as opposed to the definitions on the social media platforms, which vary very significantly from platform to platform. I hope that answers your question, and thanks for the opportunity again. Over.
Chairperson, are you online?
I think we're done. Thanks, over.
If you don't mind, let me just follow up with the chairperson.
Thanks. Yes, I see the next speaker is ready. So thanks very much to the committee and members for that opportunity. Over.
Yes, thank you very much for your time and your questions.
Thank you very much.
Good day, Mr. Rosenthal. The chairperson is just experiencing some technical difficulties. She'll be back in a minute or so.
Gershon, can you hear me now?
Yes, chairperson.
Okay, so apologies for that. I'm not even sure at what point I actually got taken off the platform, but if Advocate Wings and Mr. Bird are still around, let me just once again thank you very much for your responses and for your presentation.
You're most welcome.
Okay, Mr. Okay, thanks. Mr. Rosenthal, I see you are on the platform. Okay, Mr. Rosenthal.
Can I proceed?
Okay, no, I was just verifying if you're actually on the platform.
Yes.
Let me see. Okay, yeah, apologies. From the Association of Christian Media, Mr. Rosenthal. Let me take this opportunity to welcome you and thank you for the input that you've made on the hate crimes, hate speech bill, as well as accepting to come and make a presentation to the committee. We'll be giving you 15 minutes, and thereafter members would ask you questions for clarity. Yeah, we would prefer it if you could home in on what your issues are with bill, as well as what your recommendations are. Over to you, Mr. Rosenthal.
Okay, thank you. I'm going to start off just in terms of what I would like to frame as the priority of this bill and the need to deliberate specifically on each of these alternatives and to give due time to that. Then I'm going to give some case examples of people who recently and currently are facing unjust hate speech charges and why we don't want these kinds of things to happen further in South Africa, and even more seriously with the risk of an 8-year jail sentence. And then I'm going to outline some alternatives that can be used to improve this bill if the committee is not willing to scrap it. First prize would be to scrap this bill because I don't see a need for it, but otherwise we'd outline about 20 small changes in text which could reduce the risk of innocent people going to jail or alternatively being made afraid to express their views in the public arena. And then I would also like to rebut a collection of motivations that the Department of Justice has put forward in favor of this bill, all of which I think are flawed and inaccurate and misleading. But just to start off with my request that there is due time allowed for deliberation, and that members make use of that opportunity to deliberate on each of those alternatives and participate in that. This is the most complicated bill that I personally have ever seen, and it's also a game changer because it potentially can change the expression of political and religious opinions in this country, which then impact on the actual democracy and all other laws in this country. And so I will go now to a slide presentation with some of these case examples. Firstly, just to introduce, the Association of Christian Media has 70 members that are all involved in either broadcasting or print media in this country, and has been participating in many similar concerns to this bill previously. To give examples of innocent people accused of hate speech, we have firstly a feminist who in the United Kingdom, which I think that the Deputy Minister of Justice framed as a good country, who put up this billboard saying a woman is an adult human female. She was then interrogated by the police and intimidated for several hours. There was also a clash between her organization and a group of trans activists who were biological males, saying that they were female, who argued that this was hate speech. The second example is from Durban. Simeon Chetty is an evangelist who was preaching in the street and arguing why his experience of Jesus was greater than the Hindu gods. This greatly offended certain Hindus who were listening to him, and also listened to a video clip on social media of what he said. And they then made civil hate speech charges against him, wanted R1 million financial damages for his comparison. This put enormous stress on him, and in my opinion, that type of action, although it was settled out of court, is with no damages paid, puts enormous stress, and that stress would be much greater if this was a threat of jail for 8 years. The next example is the former Minister of Police in Finland, who is currently on trial for criminal hate speech charges for posting exactly what I've put on the screen here. Her name is Pavi Ransanen, and she was on trial this week. Her sentence will be heard next week, which is actually on appeal because the state was not happy with the outcome of the lower court saying that she was innocent. Now, this puts enormous stress on her. She's actually the leader of a political party in Finland, and to me that is completely unacceptable. That chills the religious and political debate. Another example was a satire, a comedy, which was recently banned on Twitter. There's a politician in America who is biological male posing as a female. The satire group put him as Man of the Year, and that was then judged as hate speech and locked out. Now, all of this would be so much more serious, as is, for example, the Finnish example. I can also give examples. The Prime Minister of Pakistan, former Prime Minister Imran Khan, is currently facing criminal hate speech charges. And I think that the members must be careful not to think just this only applies to other people. It could also apply to you one day in future. To now go to the bill itself, the most complex an important part of the bill is essentially the flow from the grounds to the definition of harm, to the offense, to the exemptions, and then a clause which essentially gives exemption from the exemptions, and as it's worded at the moment, makes the exemptions fairly meaningless, and in fact, in my view, just smoke and mirrors. So I really would like to explain what is a very major flaw with this exemption from the exemptions, in which it is pretending to give protection to religious media and artistic and scientific speech, but it doesn't actually. The question, this table breaks down the different categories of what could be penalized versus not penalized. Now, one's got a supposed exemption from these religious, scientific, artistic, and media criteria, but then at the end of it, it says that does not cause incitement to cause harm. Now, that sounds pretty reasonable if you interpret that harm as physical harm, because we actually don't want to protect anybody from inciting physical harm against other people. It's not necessary, but neither do we want to protect people, because there's already other laws that do that. The problem is that harm in this bill is defined very, very broadly, including social, psychological, emotional harm, and economic harm, which can be interpreted to oppose boycotts. And I think that boycotts are an important part of our civil society. So the part that's in yellow is the part that we have a major problem with, which is the exemption from the exemption then takes away the protection if there's an incitement or an alleged incitement towards psychological or social harm that is so the problem there is that if somebody is campaigning for a political or religious cause, and the two can opinion, somebody else can say, well, your opinion is causing social harm. And then they can say, well, by campaigning for that opinion, you are inciting other people to do something. For example, if you're campaigning against same-sex marriage, or for some cause to say, well, males should only be allowed to go into male bathrooms and females only into female bathrooms, somebody can say, well, that's causing me social harm. So that then can allow this to trigger the thing, and the entire protection of the bill becomes meaningless. So please be aware of that danger. I think that a major proposal that we have put forward to improve this bill, which has already been considered by the National Assembly, but to my unhappiness, it was voted through, and many of the people who voted it through were not present at the deliberations to listen to the reasons why this needed to be changed. So firstly, in the offense of hate speech, remove the words be harmful and just have incite harm. That is in 4.1a. Then in the exemption clause, and this is this exemption from the exemptions problem, is that you change that exemption from the exemptions to only physical harm, so that these other things such as social or psychological harm do not then nullify the exemptions. That's just inserting one word there and deleting two words from 4.1a. Then one can also add in, to strengthen it, in section 4.2, by a religious organization in public or in private. That is because some people may interpret this bill and are likely to say, well, this is only to protect actual evangelism and actual preaching in a church. Now, I don't think that's adequate. I think people who have a religious opinion should be entitled to discuss that in the public arena, on social media, on the radio, in the street, or the newspaper, or wherever they want to. So that would fix that. Then the penalties clause needs to be drastically reduced. You've got in Canada the example of 2 years. Now this is 8 years. The arguments I've outlined in our submission, the reasons why that was proposed in the National Assembly, and the reasons are all flawed. You can see those there. Then in terms of the the definition of harm, please to delete this term, vague term, social harm, which nobody actually knows what it means, and the word economic harm, because the word economic harm can then stop boycotts. And I think everybody will agree that boycotts are an important part of our consumer and our political history. So in terms of the grounds, to narrow the grounds, I think, as some of the previous speakers have repeated, to those that are in the Bill of Rights and the International Covenant on Civil and Political Rights, which is really where our Bill of Rights gets that from. Those are internationally tested. The longer the list, the more the risk of problems. But of those rights, the most problematic is this one, gender expression, because that allows somebody, for example, a biological male, to say, well, on Tuesday, I identify as a female. On Wednesday, I identify as a male. It is a completely flexible and undefined term, and that can put people's safety at risk, and particularly people the privacy of spaces and the participation of sports. Then there are a number of proposals that we put forward which could be used to panel beat the definitions in this bill into something which would be less likely to cause problems. Disagree with the previous speaker in terms of the need to define hatred. I think that we can borrow the good parts of the Kulani judgment to put it into a definition which we have proposed here. This bill will be administered mostly by a magistrate's court who is not going to have the time to go into all of the constitutional court judgments. We want to make this simple so that there can be justice. And we've put forward a proposal there. At the end of our submission in a table, one can also define, promote, propagate, or advocate. We can define the public interest as the Film and Publications Bill does. We can define social detriment, although I prefer the deletion of the word social. We can narrow the definition of harm, preferably to remove psychological and all these other things, but if one is going to keep the psychological harm, to make it as strong as possible so that it is gross psychological harm, preferably, or deep, which was the word used in Kulani. I don't accept the argument that we must just default to Kulani. Kulani was a civil case, and it's also a prime example of an actual unjust judgment where the court did not make a finding that was logically consistent with its own reasoning to the particular facts of the case. So we want to make this simple because people get emotive when there are hate speech cases, and we want to reduce the risk of innocent people going to jail, which could be you and me, or being chilled from expressing their viewpoint. Then the regulations, I would request that they be, one, put a qualification that they put out for 30 days for public comment, and that the holiday period is not counted in the reckoning of days. That would substantially reduce the risk of problems there. Sorry, is there...
Are you done, Mr. Are you done?
Yes, well, I'm happy to carry on talking, but I've done my 15 minutes. So with respect, unless I have permission to carry on, then I have to ask you permission. But I'd love to carry on.
Hello? I'm saying we you can.
You're not audible.
Continue.
We can't hear you, Chair.
Perhaps till about 20 minutes would be okay.
Okay, thank you. I would also just like to address the question raised by Mr. Mikolakis with respect to the exemption for religious groups. I would disagree with the answer of the previous speaker. I think that the exemption for religious reasons is,
can you hear me now?
Is part of the separation of church and state. It's a part of Western culture and historic law for the last about 400 years, and parallels the importance of the protection of the media and science. One can consider broadening the protection for other people, but I don't think we can consider narrowing the protection for people who've motivated in grounds of conscience. We've got a long history of people going to jail for expressing their religious viewpoints over hundreds of years, and that is essentially what shaped our constitutional democracy, was the need to protect those freedoms. The first person who proposed even the idea of freedom of speech, his name was Pastor Helways. He spent the rest of his life in the Tower of London under James I. We don't want to go back there, and so I think it's a critically important to keep that. Then, in terms of these claims that this is motivated by international law, the International Covenant on Civil and Political Rights has only 3 grounds. It doesn't say we must criminalize it. We've already fulfilled our obligations there. The South African Parliament has not ratified this covenant. Also, this Rabat plan of action on hate speech, this bill does not fill or comply with those requirements. The European guideline policy documents, which are not international law, this has been selectively quoted by the Department of Justice. It does not fit with these European guidelines, which also give balancing requirements. The claim that this is required by the Bill of Rights is false, and I think the criminal law is going to require a much higher standard than the civil law under the Equality Act. Further than that, this claim that it's required in terms of this covenant on combating racism, that is one select ground which is not controversial. It's this which is already unprotected in the Bill of Rights. What we are concerned about is this collection of other rights, which is likely to that's been added to the grounds, which is likely to lead to more conflict. Then further, if one looks at the statistics of the actual countries which the Department of Justice has itself used in its motivation documents, the homicide statistics did not come down as a consequence of hate speech laws. In some countries, they actually went up, or alternatively, they were part of a long-term downward trend over a long period, and no change is shown by the institution of the law. The one thing which has happened in these countries is the chilling effect, that people are then afraid to express their opinions on controversial issues, and that affects the freedom of the media, it affects the freedom of religion, and it benefits the most aggressive activist groups who continually lodge charges against other people, saying that who have a different view, then saying that that is hate speech. So I would argue that all of these are flawed, and we've put more detail in the submission on all of those questions. And so I would ask, first prize, don't pass this bill. Second prize, to make these changes which would reduce the risk of innocent people going to jail. So I've used my 20 minutes. Thank you.
Thank you very much, Mr. Rosenthal. My apologies. I seem to be having network problems yesterday and today, but yeah. I see you've also ventured into some questions that members would have probably asked, but let me allow members to ask you questions first. Are there any questions that honourable members would like to ask? I think Mr. Rosenthal actually ventured into that aspect as well. But yeah, honourable members? Okay, I don't see any hand. Can you hear me, Mr. Rosenthal?
Yes, I can, yeah.
Oh, you can, great, okay. I'm just worried. All right, no, it's fine. I think you ventured into some of the issues members would have probably asked questions about. So I think members are fairly well covered. But let me take this opportunity to thank you for your input and for your presentation. Yeah, thank you very much. I think our session with you is actually done. Thank you, Mr. Rosenthal.
Okay, thank you. I will make an additional written submission to further answer that question of why the religious exemption of 4.2 is necessary.
Oh, yes, yes, you mentioned that, right? Please do. Can we get it before today's Thursday, before close of business the next Thursday? Okay, we're giving people a week. All right. Okay, thank you, Mr. Rosenthal.
Okay, thank you.
Okay, members, we'll then move on to the next presentation, which is from Lita Labantu. Krishnan, are they on the platform?
Yes, Chairperson.
Yes, Chairperson.
Okay, once again, welcome. We lost you on the Wednesday, was it the Tuesday meeting?
Yes.
Yes, please continue with your presentation. I don't know what was going on with your network on that day.
Okay, thank you very much, Chair. With your permission, I'll also just take off my video so that I don't experience any further problems with my internet.
No, please continue.
Okay. Thank you very much, Chair, and all the members of the committee and other distinguished guests on the platform. A little bit about Lita Labantu. My name is Natsai Chakafawa. I'm a legal advisor at Lita Labantu. I am based in the Policy and Advocacy Department. Lita Labantu was established in 1989, and it is a social justice community organization based in Guguletu Township, Cape Town, and our focus is on addressing violence against women, children, vulnerable groups, and supporting those affected by it. We find the resolve and strength to comment on this bill because of the scope of our work that is centered around meeting the needs of communities that are affected by high levels of violence in the form of domestic violence and gender-based violence. As we all know, gender-based violence has crippled our communities, and we have seen now over the years the plight faced by women, children, and the vulnerable. And I also include the elderly, the LGBT communities in the form of abuse, even secondary victimization, and the trauma that is suffered is ever increasing. And we also acknowledge that the prevalence of violence is not a uniquely South African problem, but we also welcome every attempt to rectify where there has been failure to properly implement strategies in addressing this violence in our society. The organization is in general is in favor of the bill because we do believe that it aligns with the broader arguments that support limiting hate speech, addresses intolerance over the diversity in South Africa. The organization's support is based on the commitment to fundamental human rights, equality, justice, and the provisions of the bill to protect individuals from hate speech based on various grounds, including gender, race, sexual orientation, and religion. We also want to see a culture of respect, of diversity and inclusion for all the people who live in South Africa, and we are certain that the bill purports to align human rights obligations with global efforts to combat hate speech and all forms of discrimination. We also take note that hate speech affects marginalized and vulnerable communities and would like to see the protection of these rights and well-being of these groups. We are only going maybe to address the concerns we put in the written submission based on the overall intentions of Section 7 and Section 9, which deal with the national instructions and directives, as well as the prevention of the hate crimes and hate speech, Section 9. On national instructions and directives, we welcome the coordination and the collaboration among the South African Police Services, the Department of Justice and Constitutional Development, and the NPA to align efforts to work together on issuing instructions and directives that will ensure clarity and consistency in the implementation of the hate crimes and hate speech laws, policies, and procedures so that there is consistency. We, however, have to submit that in terms of training that is to be done with SAPS, with the NPA, and sometimes with the DOJ, there's often lack of compliance and accountability, seeing that these departments may be under-resourced. We have non-profit organization stakeholders who are able to give training because of their experience in the space, perhaps because of the work with different communities. We would like to submit that these stakeholders be instrumental in terms of also providing the much needed training and sensitization to these departments. Many NPOs also include ourselves, Lita Labantu, often conduct educational programs and awareness campaigns. And through these initiatives, we are able and we are qualified to advocate and counteract the divisive nature of hate speech crimes. The ability of NPOs to collaborate means we are vital partners to the government in contributing to the achievement of the purposes of this bill. In terms of Section 9, which is the prevention of hate crimes and hate speech, we note and welcome these provisions, especially the commission given to the South African Human Rights Commission, the Commission for Gender Equality, and the Commission for the Promotion and Protection of the Rights of Cultural, Religious, and Linguistic Communities. We have to submit that we do see no effort to bring on board the Department of Basic Education to promote awareness, seeing that the Department of Basic Education is responsible and has a mandate to oversee primary and secondary quality education in the country. The Department of Basic Education is instrumental in shaping the educational landscape and therefore plays a very crucial role, we believe. Incorporating hate speech crimes into the curriculum, we believe, will be a proactive measure to address societal issues and will promote a more inclusive society, knowing that South Africa also has a literacy crisis and the general population, that is those not seeking further education or even higher education, after leaving school will not pay attention to any other forms of learning. We believe it is therefore important that basic education empowers the next generation to be well informed and committed to upholding democratic values of human rights, equality, promotion of tolerance, and respect for diversity. We therefore believe that the Department of Basic Education must be roped in to develop the national curriculum, promoting the objectives of this bill so that there is improvement in the quality of awareness that must be achieved. And we believe that this will provide a foundational understanding of the legal framework for hate speech crimes, which will also then promote deterrence. In conclusion, Chair, Lita Labantu supports the bill because we believe it is going to strike a balance between freedom of expression and the protection of vulnerable individuals and communities. I thank you.
Thank you very much for your presentation. Honourable members, do you have any questions for clarity? I think the presentation was quite specific to certain clauses in the bill. Is there any member who has a question for clarity? Honourable Dovo?
Yes, Chair. Just a straightforward one. I follow these organizations. The presenter said, when were they founded?
In 1989.
1989.
Correct.
And are you a coalition or you are just a body? Yes, in that sense.
We are a non-profit organization that offers psychosocial support and legal services to all the survivors of violence.
No, it's okay. I'm satisfied. The presenter was very clear and eloquent, Honorable Chair. Thank you.
Okay, no, thank you very much, Honorable Dodovu. I think, ma'am, that was just one question to you from the Honorable Member, but thanks for responding to that. And thank you for making your presentation to us. Like I said, you were quite specific on specific clauses. Thank you, ma'am. Okay. Our members, Gershon, we've exhausted the schedule, right?
Chair, we have Mr. Nkosi online, Chair, from the Council of Charismatic Churches.
Oh, yes. All right. Mr. Nkosi, are you online?
Yes, Honorable Chair.
Okay. Let me just take this opportunity also to welcome you. Honorable members, perhaps I didn't explain this bit to members, but I think it was yesterday or so that Mr. Nkosi came back to us to say that he would want to make that presentation. So, yeah. Mr. Nkosi, as I'm sure you're part of this process, as I've indicated to other presenters that will be giving you 15 minutes, and if you could please try and focus on your proposals of the bill and the recommendations.
Okay, thank you, Honorable Chair. Thank you to the committee for the opportunity they have afforded us as Council of Charismatic Churches to make an oral presentation to this important piece of legislation that is proposed. Yeah, then in the interest of time, I will just, because you have the presentation with you, yeah, so I'll just zoom into especially key areas that are of concern for us, you know, as a body that represents 1.3 thousand, you know, leaders. And then after following, you know, what that voting session at National Assembly, a lot of what was happening there was so concerning. And some of the points I've highlighted in the introduction, but what is of concern, it's issues like weaponization. You know, we see, you know, as this body that represents the both Pentecostal charismatic churches, that this legislation has an element of weaponization. We see it as a weapon that is designed against pastors. And I have a reason why I say that. I also stated we also stated in the document, because when we were following the session at Parliament, you know, we had a presentation by Honorable Maseko Jele and Honorable Deputy Minister Jeffries, who said two statements that are concerning. And, you know, if I quote Honorable Jele, this is what she said on that day when a vote was done at National Assembly, that we are making sure that the preachers must stay on the line. When you preach the gospel. Stop talking things that will be insulting to people. That was so concerning. And the concern was, what exactly does she mean? And secondly, what does she mean by stay on the line? And what does she mean of the gospel and talking things that will insult people, of which is something that we still need accountability on that statement as, you know, church leaders. Yeah, because we are asking ourselves, you know, in terms of competence and so on. So we see that said to us, this thing, it seems like is directed at us. It's being weaponized. And the other thing that, you know, Deputy Minister highlighted in that session at the National Assembly was saying, you say you preach love, you know, there are organizations like so and so, but you have issues with, you know, people, especially of the LGBTQI community and things like that. Those are some of the things on the aspect of weaponization that we have hinted and we are concerned about. We still need clarity on that thing. And it's unfortunate that even the National Assembly, we just wished we had that opportunity to even tackle that on that day. Unfortunately, we were not present at that time. And the other thing was the issue of definition of weights. You know, I mean, the battle for the definition of weights, like your harm and so on, it was a struggle. I had to watch a 7-hour, you know, alongside my colleagues, you know, of that session of the Kwelane case, you know, both the justices at the Constitutional Court and even, you know, the advocates that were presenting there, they were battling. And now and then, when they were trying to define the word harm and hate speech, they were defaulting in their, understanding. They were always defaulting to hate crime, of which is something that is so clear. And then, so not even the Constitutional Court, could come up with a clear-cut definition as to what is the difference between hate crime and hate speech. They would use words hate speech, but as they define, they defaulted to the definition of hate crime. And something also during that parliamentary session on the voting of this bill at the National Assembly was that, one of the two of the honorable members, both from the EFF, and, from the ACTP, Honorable Swart and Honorable Yako, they hinted something regarding definition. So that says to us, now both the Constitutional Court as well as Parliament itself, members of Parliament, could not define what hate speech is in a clear-cut difference to say what this is. But it's unfortunate that, it was voted through because it was voted through, but still questionable. But we are just happy that at least with this committee, we are able to add these issues. The other thing that we have highlighted, we see a duplication of legislation and violation of the Constitution, because we see a repetition of legislation, especially of your Section 10(1) of Equality Act, which is PEPUDA, and as well as Section 16(2) of the Constitution, which already make provision for hate speech and the grounds thereof. And, the issue of the Twelani case says, now on the issue of hate speech, if it was an issue like in dealing with this bill, if dealing with this bill is an issue, then that would say that case would have not been resolved. For the fact that it was resolved and there was a judgment that was passed by the Constitutional Court on that issue of that case, it says there are legal instruments to handle the issue of hate speech. And on the issue of proposed penalty, it cannot be, like appropriate for a pure hate speech offense to bear the same weight of hate crime. If hate crime and hate speech, hate crime and hate speech are differently defined, by this proposed bill, then why definitions need to be clearly cut between the two? To minimize confusion. So issues like that, if hate crime and hate speech are the same thing, because you can't judge the same two different things and apply same sentences to that it's a question mark. And so to carry that penalty, it's really questionable. And on issues of recommendations, we just proposed, to the committee to convene a consultation session with the religious sector, because something that we have witnessed, not only in Parliament, but as well as the judiciary and the executive, the three-tier of government, is the issue of, education. Our judiciary, our Parliament and executive, they are not that, competent or understanding the sector. And it's been in different situations and cases where that we picked up, as I've highlighted what the Deputy Minister said. When I listen to that, him saying that, it says he does not understand what the sector is all about. It's based on assumptions or maybe something of old past knowledge, as well as Honorable Jele on that matter. So there's a need and a gap for education of both Parliament, the executive and the judiciary on matters, that affects the religious sector. And I've followed, the conversations since, Tuesday. And it's unfortunate that I don't see the CRL, making oral submissions. It would be good to have had them as well, because as custodians of our sector, within, that the constitutional mandate they have, I wished they were also, here to input on this and educate some more on the sector. And again, the issue of this consultation will be helpful, for Parliament to be educated on religion or on religious matters, so that when issues that are around religious matters are tackled, then it could be, from that point of understanding. I see a lot, even in other Parliament sessions, on other issues, ample time is spent on dealing with that, but I haven't had a situation where Parliament really deliberate fully on the matters. And lastly, as recommendation, the total scrapping of this bill, we see it as unnecessary, because the laws that are present, they are available. And I think, as the last thing to say, some things are based on assumptions, especially within the sector. I have two people who are my friends from the LGBTQ AI community, and we differ, based on my beliefs, in terms of their position and so on. But I don't have a phobia. I relate with them. We caucus, we joke, we have wonderful moments. They know we disagree on that position based on the belief, but that does not constitute that I'm homophobic. Words like homophobic, I feel like they are being thrown around because you disagree with a position, therefore you are labeled and you are called names on the grounds of that. As to the issue of, love, you can love a person you are different with. Thank you.
Thank you very much, Mr. Nkosi, for your presentation. Honourable members, do you have any questions for clarity? Okay, I think, Mr. Nkosi, we do have your written submission. I should also indicate that we do have the written submission of CRL as well. In as much as we've done oral submissions, the written submissions still stand in terms of what we've received as well. But let me take this opportunity to thank you very much for making your presentation to the committee. And I think our session with you, is now done. Thank you very much, Mr. Nkosi.
I appreciate that, and the members of the committee.
Okay, honourable members, I think to confirm we're done with the schedule.
No, that's correct, Chairperson.
Okay, all right. No, honourable members, we've come to the end of quite a lengthy and thorough process over the past 3 days in terms of the hearings on the hate crimes, hate speech bill. Let me thank each and every organization and or individual who made a presentation to the committee. But let me also thank committee members for their engagement on the submissions that were made. Let me thank the department and the legal advisors for their attendance, and their attention to the submissions that have been made. I think the submissions has brought forth points for the department to note and to respond to in the next meeting of the committee, which we will communicate with members in due course. I think that being said, honourable members, let me thank you again and declare this meeting closed. Okay, I hope I was audible.
Thank you, Chair. Bye.
Thank you.